From today, a social landlord in Scotland can ask a court to take an abuser off a tenancy and leave the person who was abused in the house. Not rehouse them, leave them where they are. So, as always, identify the document first. Scotland only. This lives in the Housing Scotland Act 2001, so it reaches social tenancies, not private ones and not England, Wales or Northern Ireland. The commencement order is the Domestic Abuse Protection Scotland Act 2021, Commencement Number 1, Regulations 2025. Regulation 2 appoints the 1st of August 2026 for two things only. Sections 2 and 3 for the purposes of Part 2, and Section 22, that is the whole instrument. Part 1, the Domestic Abuse Protection Notices and Orders, is not commenced. If you have read that Scotland got emergency protection notices today, that is not what happened. Section 22 is not freestanding either. It amends the Housing Scotland Act 2001, rewriting sections 14 and 16 and inserting a new ground, paragraph 15A, into Schedule 2. Schedule 2 supplies the grounds for Section 14 proceedings, the Scottish Secure Tenancy route. Short Scottish secure tenancies are reached by a second step at Section 36, subsection 7, which is without prejudice to Sections 14 and 16. The statute uses its own labels. Person T is the tenant. Person P is the person being abused. The ground is made out where person T has engaged in behaviour which is abusive of person P, a partner or ex-partner, and four conditions are met. Person T is the sole tenant, or person T and person P are joint tenants. The house is person P's only or principal home. Person P wishes to continue living in it, and the landlord wishes to recover possession from person T in order to grant a tenancy to person P, or to end a joint tenant's interest. Read the third one again. Person P wishes to continue living in the house. If that is not so, the ground is not made out. Partner or ex-partner is defined narrowly. A spouse or civil partner. A former spouse or former civil partner. Or someone person T has lived with in the house as if a spouse for at least 6 months in the 12 months before proceedings. Abusive behaviour is not defined in the Housing Act at all. It is imported from Sections 2 and 3 of the 2021 Act. That is why those two sections were commenced for the purposes of Part 2. Section 2. Behaviour is abusive if a reasonable person would consider it likely to cause the other person physical or psychological harm. Psychological harm includes fear, alarm, and distress. Section 3 elaborates. It includes behaviour that is violent, threatening, or intimidating, and behaviour whose purpose or likely effect is making the person dependent or subordinate, isolating them from support, controlling or monitoring their day-to-day activities, restricting their freedom of action, or frightening, humiliating, degrading, or punishing them. Coercive control sits inside this definition. Now, the part most write-ups get wrong. This is not one power, it is two, and which applies depends on whose name is on the tenancy. If person T is the sole tenant, the landlord raises proceedings under Section 14, subsection 1, paragraph A, for recovery of possession. If the court makes that order, Section 16, subsection 5, terminates the tenancy. Then subsection 7 does the thing this power exists for. No later than 28 days after that termination, the landlord must offer a tenancy of the house to person P. Subsection 8 is the release valve. Not if that is impossible or inappropriate because of circumstances relating to person P. If person T is a joint tenant, nothing is recovered at all. Paragraph B lets the landlord ask for termination of person T's interest instead, and subsection 5C of section 16 ends that interest on the date in the order. Person P was already a tenant and stays one. Whichever route, section 16 gives the court two ways to reach the order. Only one involves a conviction. The first. The landlord has the paragraph 15A ground. It is specified in the section 14 notice, and it is reasonable to make the order. On that limb, subsection 3ZB tells the court to have particular regard to any risk of further behaviour. The second applies whether or not the first does. Person T has been convicted of an offence in respect of that abusive behaviour, punishable by imprisonment, and the notice was served within 12 months of the conviction or of an appeal being dismissed or abandoned. On that limb, reasonableness is not asked, and this is a court process throughout. Summary cause proceedings. No landlord can end a tenancy or an interest in one by notice alone. Where the test is met, the wording is that the court must make the order. Which brings us to the paperwork. Before proceedings, the landlord must serve a notice on the tenant and on any qualifying occupier. It must specify the ground from Part 1 of Schedule 2 and a date not earlier than 4 weeks from service. So, on a Section 14 notice, look for the ground. Paragraph 15A has to be named on the paper, because every limb of Section 16 only lets the court make the order on a ground specified in that notice. 3 duties sit on the landlord. Before raising proceedings, have regard to guidance published by the Scottish ministers. As soon as reasonably practicable after raising them, give the tenant and any qualifying occupier advice and assistance on finding alternative accommodation. Then, the 28-day offer. Be clear what that guidance is. The Scottish Government published it in June 2026. The duty to have regard to it is in the Act. The guidance itself is not the law. 4 things are being said about today that the provisions do not support. Myth 1. Scotland has new domestic abuse protection notices from today. It does not. Part 1 is not commenced. What commenced is a housing ground, and the 2 definition sections it borrows. Myth 2. The landlord can now remove the abuser. The landlord can raise proceedings, only a court makes the order, and only on a ground specified in a notice served in advance. Myth 3. You need a conviction. You do not. The conviction limb is an alternative. The reasonableness limb stands on its own. Myth 4. The house automatically transfers. In a sole tenancy, the landlord must offer a tenancy within 28 days, unless that is impossible or inappropriate. In a joint tenancy, nothing transfers, because person P's tenancy was never ended. And one honest limit. At the time of publication, there are no reported court decisions interpreting these provisions. This episode explains the legislation as in force on the 1st of August 2026. So the method. Identify the instrument and check what actually commenced. Identify the tenancy, secure or short secure. Look at the notice for the ground. Work out which root, sole or joint. Then which limb, reasonableness or conviction. The myth hands you a headline about sweeping new powers. The method hands you a notice and a number to look for on it.